Good evening, everyone. So good evening, Harry, Karina, Rebecca, and Clinton. Thanks for joining tonight's session, which we are devoting in relation to the topic on judicial review remedies. So you should be happy about the fact that we are now in week 10, and we're just 2 weeks away from the term finishing, which means that you're getting closer to completing our unit in administrative law. So well done. And tonight, the topic on judicial review remedies is very important, mainly because it's one thing for us to know that there is the availability of judicial review, and so you can go to the courts to have an executive decision reviewed. But then, as we learned, for example, in the case of Green versus Daniels, it is not often the case that even if an applicant may actually succeed in having his or her case being reviewed by the court, it will not often be the case that the court will actually grant the remedy sought by an applicant. So at its very core, we would recall that judicial review remedies are very limited. So judicial review in general is very limited in the sense that courts do not have the power to step into the shoes of the original decision maker. And typically what the court can do is simply to quash or set aside a decision of the executive, or maybe remit it back to the original decision maker for it to review, but it cannot change or vary a decision of the executive. So you can see the limit there. Courts cannot vary the decisions of the executive because that is a constraint of judicial review. It is simply a supervisory role as far as the courts are concerned. And so therefore, given the fact that we now know that judicial review is very limited, we really need to know what exactly are the remedies that you can look at if you were to decide to apply for judicial review. Because true, you might have legal standing, true, some of your rights may have been violated, but whether or not you will actually succeed in getting what you wanted is an altogether different question. And so that's what we're going to do tonight. We're going to look at judicial review remedies. And so we need to bear in mind as well that if there were an opportunity to actually apply for a merit review with the Administrative Appeals Tribunal, of course you would do that because so this is just kind of a review because we're heading towards the end of the term. So there's always an advantage to undertaking an application for merit review by the Administrative Appeals Tribunal, mainly because, number one, the Administrative Appeals Tribunal has the power to vary the decisions of the original decision maker. It can, because it can step into the shoes of the original decision maker and substitute its own decision for the original decision maker. So it can do whatever it likes. And we also know that as far as merit review is concerned, it is not even limited to making a decision on the basis of a factual error. When you have a recourse to the Administrative Appeals Tribunal under the Administrative Appeals Tribunal Act of 1975, we know that the Administrative Appeals Tribunal can make decisions on the basis of questions of facts, questions of law, questions of policy, and even the exercise of discretion. So we know, the part of the powers of the AAT involves making a determination as to the correctness or preferability of a decision. So that is, if that is available, you would want that. But we also know that there are constraints in relation to merit review, mainly because for there to be a review available on the part of the Administrative Appeals Tribunal, the decision must have been based on an enactment, and that particular enactment must itself provide that an application for review to the AAT is available. So you need to meet those two requirements. When you speak of judicial review remedies, on the other hand, for example, if you talk about the broad powers of the courts pertaining to common law judicial review, or particularly in relation to Section 39B of the Judiciary Act of 1903 Commonwealth, there is no requirement that any particular law or any particular enactment must provide jurisdiction on the part of the courts, because there is a common law, precedent that courts do have the power to supervise the actions of the executive, especially when those actions of the executive are contrary to law. So courts have asserted their power to control excesses on the part of the executive. So you don't need an enactment for that. And in fact, if you look at the Constitution, particularly Section 75(5) of the Australian Commonwealth Constitution, it is even a constitutionally provided power on the part of the High Court in the exercise of its original jurisdiction to issue writs of mandamus or prohibition or an injunction against an officer of the Commonwealth. So there is no requirement that an executive decision has to be based on an enactment, either on the basis of Section 39B of the Judicial Act of 1903 Commonwealth, or, for example, on the basis of Section 75(5) of the Australian Commonwealth Constitution. And as I have said, we know that there are common law judicial remedies. So even if outside of these statutory authorizations, meaning the Judicial Act of 1903 Commonwealth or the Constitution, which is Section 75(5) of the Australian Commonwealth Constitution, there is recognized a common law power on the part of the courts, obviously, to police the exercise by the executive of their decisions when these are contrary to law. Now, what is crucial as well is that we now have not only, so we've now talked about, briefly, we've talked about the power of the High Court to issue writs of mandamus or prohibition or injunction against an officer of the Commonwealth. So note, it has to be an officer of the Commonwealth. So if the person involved is not an officer of the Commonwealth, so for example, it could be that, typically you can have an enactment that, for example, creates the Australian National University. So in that case, you can have judicial review under the Judiciary Act of 1977 Commonwealth. You potentially can have the judicial review in that sense, because the ANU, when it makes a decision, if the decision was based on an enactment, then you can have judicial review under the Administrative Decisions Judicial Review Act of 1977 Commonwealth. But it is not an officer of the Commonwealth. So in that case, for example, there are no remedies under Section 39B of the Judicial Act of 1903, nor, and that pertains to the Federal Court of Australia, neither is there an availability of judicial review with the High Court. Because again, in that example I gave you, we're speaking here of the ANU, which is not an officer of the Commonwealth. So the discussion about judicial review is actually quite tricky. And we will see that when you speak, for example, about common law judicial review remedies, or in particular, when you talk about equitable judicial review remedies, we will realize and see that there are many restrictions. So you don't just get it. So they're essentially discretionary. And so there's the beauty in the sense that the Commonwealth Parliament decided to pass the Administrative Decisions Judicial Review Act of 1977 Commonwealth, because it has essentially given broader powers of judicial review. And the constraints, the limitations that were inherent in the common law and prerogative judicial review remedies have now been supplanted by the Administrative Decisions Judicial Review Act. So in other words, when the Federal Circuit Court or the Federal Court of Australia exercises judicial review on the basis of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, they are no longer as restricted as they would have been in terms of providing judicial review remedies had they been exercising, for example, common law judicial review remedies. So these are things we need to examine tonight. So again, just to quickly, provide a reminder, the preference would be that, if merits review is available, you certainly apply for that. But your problem is not only must the executive decision have been based on an enactment, that particular enactment must also provide that an application for merits review can be had with the AAT. So those are twin jurisdictional requirements. Now, if you cannot have the merits review, which would have been better because it looks at the law, it looks at the facts, the exercise of discretion, or the application of policy, then your next recourse would be to examine the possibility of undertaking judicial review, which is quite expensive, as we said, and stringent, and there are rules of evidence. But in that particular case, if you don't have any choice, but you have to undertake judicial review, your best recourse would, of course, be to seek judicial review under the Administrative Decisions Judicial Review Act of 1977, Commonwealth. Because as we said, the judicial review remedies under that particular statute are broader and less stringent than the common law or the equitable judicial review remedies. The only problem, however, as we said, is that as far as the ADJR Act of 1977 Commonwealth is concerned, the executive decision must have been based on an enactment. Okay, so in other words, if a decision was made by an executive on the basis of the exercise of its inherent or prerogative executive powers, then you cannot have judicial review under the ADJR Act. Remember? So that's a core principle there. Now, on the other hand, assuming that the ADJR Act is unavailable, because as we said, the executive decision was not based on an enactment, then that's when you examine the possibility of applying for judicial review on the basis of the common law. So, on the common law, courts have the power to issue res mandamus or prohibition. And in particular, you can also look at statutory judicial review remedies in the case of the Judiciary Act of 1903 Commonwealth, which pertains to the power of the Federal Court of Australia to issue res mandamus or prohibition or injunction against an officer of the Commonwealth or on the part of the High Court when it comes to Section 75(5) of the Australian Commonwealth Constitution. Okay, so that's a good backgrounder. And so for that, because of that, it will be crucial for us to examine judicial review remedies. So after studying this topic, you should be able to discuss and explain the distinction between common law prerogative judicial remedies and equitable judicial review remedies, the specific common law prerogative judicial review remedies of certiorari, mandamus, prohibition, and habeas corpus, and the specific equitable judicial remedies of declaration and injunction, and the statutory judicial review remedies. Any questions so far before I continue? Questions, comments? So we're good. Okay, now, as we always do before we start talking about the discussion questions for the week, usually touch upon the quiz, mainly just to provide some guidance and to highlight a few points without really providing the answer. But the quiz does provide a good backdrop for us to think about the weekly topic. So that's what we're going to do tonight. We will begin by looking at the quiz. So can I ask one of you to read quiz 9 for us, which is the quiz for this week? Can I get a volunteer? And please unmute yourself when you do.
Hello?
Thank you, Clinton. Very good.
Yep. The Australian Minister for Small Business, the Minister, reported at a session of the Commonwealth House of Representatives that he had in her possession a special report about small businesses that are likely to be involved in money laundering and organised crime. He said that in due course he would submit a bill and attach and publish a special report thereto that would introduce more severe penalties for small businesses that are involved in money laundering and organised crime. On the basis of a Freedom of Information Act request, XYZ Proprietary Limited was able to acquire a copy of the special report that, as it feared, named it as one of the small businesses that was alleged to be involved in money laundering and organised crime. Fearful that the release of the special report would damage its business. I think the screen's just died there.
Is something happening? You're good.
Reputation, XYZ Proprietary Limited has come to you as solicitor for advice. XYZ Proprietary Limited is aware that the Minister is not exercising a statutory power in seeking to publish the special report. Yep.
Go on.
Which of the following statements is the most correct? XYZ Proprietary Limited should be advised to apply for an issuance of the writs of prohibition and injunction in the application for a judicial review with the Federal Court of Australia under Section 39B of the Judiciary Act 1903 Commonwealth. XYZ Proprietary Limited should apply for a judicial review under the Administration Decisions Judicial Review Act 1977 of the Minister's decision to publish the special report about small businesses that are likely to be involved in money laundering and organised crime. The publication of the special report, even if it identifies the small businesses that are alleged to be involved in money laundering and organised crime, is a non-justiciable question and not apt for judicial review. And D, we've got, given that the special report has not yet been published, XYZ Proprietary Limited has no legal standing to apply for a judicial review. And E, XYZ Proprietary Limited should be advised to apply for an issuance of writ of mandamus in the application for a judicial review with the Federal Court of Australia under Section 39B of the Judiciary Act 1903 Commonwealth.
Okay, very good. Thank you, Clinton. Now, just going to put letters there. We'll do two things as usual. First, I'd like you to attempt an answer to this quiz by typing your answer in the chat box. So you simply have to say, choose any of the letters there. And then after that, I'll try to ask you to provide an answer. What you think is the correct answer, if you could just attempt it. I could also highlight a few points, but in the meantime, can I just get all of you to attempt to answer quiz 9? So I gauge a level, I get a sense of what you think is the correct answer to this quiz. Got an answer from Rebecca. Okay, how about the others? Because remember, if you're going to be lawyers, you need to suggest to your client what he should be doing. It's one thing for you to say, you can apply for judicial review, fine, but what's the remedy? So you need to be able to know what the remedies are, and particularly you want to know what law you're relying upon. Is it based on the common law? Is it based on the ADJR Act? Are you looking at the Judiciary Act of 1903? Are you looking at Section 75(5) of the Constitution? Okay, so we've got an answer from Rebecca, from Karina, as well as from Clinton. And I get an answer perhaps from Tim and Harry, if that's all right. No one's going to see the answers in the chat box anyway. When we put this on YouTube, your answers are not going to appear. So it's just going to be a very, it's just a learning exercise that I'm asking you to type an answer. Okay, from Karina, she's given 2 answers. Okay. Tim got too late to answer to see the question. Okay, I'm not sure about Harry. Okay, so perhaps Harry has some difficulty there, typing in an answer. Okay. Harry has an answer there. Very good. So, very good. So whilst there was some kind of a, initially some disagreement as to what the correct answer was, I now see 3 students who've converged upon an answer, and that answer actually, now I'm not going to say whether it's correct or not, but I'm going to leave it to you. Very good. What are your comments? So let's have a look at the facts. Again, as a way of us being more enlightened about judicial review remedies. So let me just highlight a few things. We will notice that the decision was made by the Australian Minister for Small Business. Okay, and in doing so, we will notice that, or we should notice that the decision of the minister is not based on the exercise of a power under an enactment. It doesn't say. Okay, there's nothing in the facts that would tell us that the minister is exercising his powers on the basis of an enactment. He seems to be exercising his inherent powers as an executive, which leads us to that basic question. Would judicial review be available under the ADJR Act? That's the question, and I think we covered that already. So you would have an answer to that. What exactly was the answer there? So if a minister is exercising, his or her inherent executive powers. In other words, it is not a statutory power that an executive is exercising, would judicial review under the ADJR Act be available? Can you answer that with a yes or no in the chat box? Let me just see for now if it's all right. So if a minister is not exercising a statutory power, would judicial review be available under the ADJR Act? Yes or no? Very good. So you got the answer there. That's very good. So it's very clear to everyone that when an executive is exercising an inherent executive power and it's not a statutory power that is being exercised, in other words, he's not relying on an enactment, therefore, the ADGR Act is not available. So we already are able to knock off one of the answers there. Now, what else do we know about that? The other question we have to ask is the minister an officer of the Commonwealth? Because the example I gave earlier, it might be that had we changed the facts, and let's assume that it was the Australian. Oh, I've got an answer from us. Can I just answer this message from a student? Because he is asking if you could join us. I don't know who this is, but if it's all right, I'm just going to answer this. So where was I? Okay, so imagine a situation where we kind of have an instance where the Australian National University, which is created under the ANU Act, Commonwealth, and let's assume that the ANU felt that some students were cheating and it wanted to publish a report, or let's assume that it felt that some academics had engaged in plagiarism, and to shame them, it was thinking of releasing a report. So in that case, if we kind of change the facts, the question we then have is, assuming for the moment we do not talk about the ADGR Act, the question I really wanted to ask was whether or not there would have been potentially there could potentially be an application for judicial review under the Judiciary Act of 1903, Commonwealth, particularly Section 39B. So in other words, the basic question there was, would the ANU be an officer of the Commonwealth? I think you have cut the Zoom link off of the front page, or did I? That's right. Okay, I was just looking at the point from Clinton. That's probably why did I cut off the Zoom link on the front page? Oh, okay. Oh, okay. I may have made that mistake. Hopefully the student will join us shortly. Okay. So Karina is correct. In the example I gave, okay, not per talking with the quiz, in the example I gave of ANU, trying to make a decision which would have violated the right to natural justice of students or teachers, the ANU is not an officer of the Commonwealth, and so therefore you cannot have recourse to the Judiciary Act of 1903, Section 39B in relation to the Federal Court of Australia, nor can you have recourse to the original jurisdiction of the High Court under Section 75(5) of the Australian Commonwealth Constitution. Okay, so very good. Now, so what do you think? So, so this one, we've covered that, and I don't know. We have an answer to that, right? That point about a non-justiciable question, did that involve a non-justiciable question? Because remember what had happened here is there is an attempt to publish a report that could be, clearly damaging to the reputation and to the rights of a company. Does that involve a non-justiciable question? What exactly is a non-justiciable question? What do we remember about justiciability? What at its core does justiciability mean? Okay, so just as a reminder, when we speak about justiciability at its core, we're actually trying to determine whether there is a matter that is involved. So matter is a legal term, okay? There is a matter when there is involved an actual controversy. So it's not a hypothetical or a theoretical question. There is an actual controversy involving the rights, freedoms, liberties, or interests of an individual. Okay, so it has to be an actual controversy, and it involves the rights, interests, or legitimate expectations, or liberties or freedoms of an individual. So if it's hypothetical, then there is no matter. Then in that case, you will have a non-justiciable question. But certainly, if a decision is about to interfere, or impinge, or impair the rights of a person, is that a justiciable question? It certainly is, I think. Okay, legal standing. That's the issue about legal standing, is closely related to the actual controversy. If your rights are about to be violated, necessarily you do have legal standing. Okay? Now, what do you remember about the writ of mandamus? The writ of mandamus involves an order from a court to compel the performance of a public duty that hasn't been performed yet. So there is a public duty. So you wonder, does the scenario here involve the performance of a public duty that hasn't been performed? Is there a public duty of any sort? So if you were the lawyer for XYZ Proprietary Limited, if it's a writ of mandamus, you're actually trying to compel the minister to publish the report because you think that there is a public duty. Well, there will be the question of whether or not there is a public duty for the minister to publish the report. But secondly, why would you do that? You want the minister to publish the report. So which leads us to the question of, how about the writ of prohibition and injunction? And we could probably revisit that because, as I pointed out, 3 students got the answer correctly. So you have a sense of what the answer to this will be, but I will leave it at that. And we could probably move on to question 1. Okay. Am I getting another? Wait, give me a second. Okay. If you don't mind, we've got a student who really wants to join, so I'm just going to quickly do this. What's the meeting ID? So the meeting ID is, 827 319 397. Okay, sorry. I'm going to turn that off so I don't get interrupted. Can I get someone to read question 1 for us?
I'll read it for you.
Thank you, Karina. Go ahead.
Darren Wilkins operates a car rental business and has been doing most of business accounting tasks on his own. He audit by...
Sorry. It's Michael. You're actually in the wrong, sorry. I didn't know who was, Michael, sorry. I didn't know who was sending me the message. I thought there was a student. You're actually in my administrative law class, Michael.
I gathered that, Manjo. I just wanted to interrupt.
Yes.
The meeting ID in Moodle for the laws class is already open and it won't let me join. So
I think
I've sent another email, just to let you know. I'm sorry to interrupt everyone. I've sent an email to all of the students, well, I think 7 of them, with a new ID.
Okay.
But I'm not sure that any of them are online because none of them have joined. So I'm going to try another ID and send another, and I'll stay online for another half an hour or so.
Well, Michael, if not, if it's in the consolation, there's only just 1 student who joins that tutorial. So it wouldn't be surprising if no one actually appears. I'm just saying.
Again, what I will do is go online again. I'll send an invitation and I'll wait for another 20 minutes, half an hour. Okay?
Thank you, Michael. Sorry about
Sorry to interrupt, Manjo. I'll talk to you the next day or 2. Okay?
Thank you. Bye.
Bye.
Okay, so let's continue. Okay, Karina, can you continue with, so that was actually Associate Professor Michael Segan, who's the head of the MBA program, and I am unit coordinating another unit in the MBA program, Governance and Business Law. And he was going to be facilitating the tutorial tonight for one of the sessions. But I got mixed up with the tutorial schedules because obviously I didn't know I couldn't use the same Zoom meeting ID. So that was the reason. I didn't know it was Michael that sent me the message. Okay, sorry about that, Karina. Do you mind going through the question again for us, please?
Okay, I'll read it again. Darren Wilkins operates a car rental business and has been doing most of business accounting tasks on his own. An audit by Australian Taxation Office, ATO, revealed that he had misinterpreted key provisions of the Australian tax laws, and as a result was deficient in the payment of taxes in the amount of $59,965. The ATO informed him that under the relevant tax laws, he must pay his tax deficiency within 15 days, or it would garnish all his business and personal bank funds. Darren has come to you as a solicitor for advice. Advise Darren on the judicial remedy or remedies that are suitable to prevent the garnishment.
Very good. Okay. What is one of the key observations that we can have here? Who is making the decision? Is the decision, what power is being exercised by the executive in relation to, the decision to garnish the funds? Is that executive exercising statutory powers, or is that the exercise of executive powers? And what type of executive is that person? Is that an officer of the Commonwealth or not? So very good. So Karina has observed that we're dealing here with a Commonwealth officer. The second question we need to ask is the officer exercising his powers under an enactment, or is he perhaps exercising his powers on the basis of an inherent executive power? Okay. So Karina makes the observation that he is exercising his powers under the relevant tax law, so under an enactment. Oh, very good. He had misinterpreted key provisions of the Australian tax laws. Very good. Well done. So he's actually exercising, very good. I didn't notice that, Karina. Well done. So it's under an enactment. What is the significance of that? So if it's under an enactment, what is the significance? What particular law can we cite, or on what basis can we ground the jurisdiction of a court in undertaking judicial review? So very good from Karina. We can use the ADJR Act. Very good, because the minister, the ATO, in imposing, in undertaking a decision to garnish the funds of Darren Wilkins, is exercising powers under an enactment. And so therefore, if it is under an enactment, we know that there is judicial review that's available under the ADJR Act. Very good, so we know that. Now, so if we rely on the ADJR Act, then what particular judicial review remedy or remedies would be suitable to prevent the garnishment? So you will notice when I ask this question, I'm no longer asking about whether judicial review is available. We now assume it is. The question now is, what exactly is the judicial review remedy? Okay, can Clinton tell me what Section 16 is? Yes, Clinton? So Section 16, Clinton? So Section 16. Yes, go on.
Section 16 is where all the writs are available, and I'm just trying to find out which one it is. So I think he'd be hoping to stop them from doing something, so like an injunction.
Very good. So Clinton is correct. So because we've already said that judicial review under the ADJR Act is available, we then wish to know what exactly are the powers of the court under the ADJR Act. And as correctly pointed out by Clinton, under Section 16, particularly subsection 1 of the ADJR Act, the Federal Court of Australia, as well as the Federal Circuit Court, has in their discretion the power to make any of the orders under Section 16, particularly Section 1D, as pointed out by Clinton. Clinton, can you tell us what it is, Section 1D? So if you look at Section 1, yes, Section 16.
Yeah, can you hear me?
I can hear you. Go on.
Hello?
Yes, I hear you.
Section 1D, where an order directing any of the parties to do or refrain from doing any act or thing, doing or the refraining from the doing of which the court considers necessary to do justice between the parties.
Very good. Fantastic. So that's the beauty of that provision. You will realize that in particular, when you speak of Section 16(1), subsection 1, subsection D, you will notice that the remedies available under the section talk about the power of the court to order the parties to do or refrain from doing, which is really similar to the idea about a writ of prohibition or even a writ of injunction, which can be a writ of prohibitory injunction to prohibit or refrain a person from doing something. They're very similar because we will recall that the statutory judicial review remedies, both under Section 39B of the Judicial Act of 1903, as well as under the ADJR Act, are actually of common law origin. So this is, in a sense, so under the ADJR Act, in a sense, that's a codification of the judicial review remedies that have long been recognized by the courts. But because the ADJR Act does not define the writ or the order as one being involving an injunction or as involving an interlocutory order, for example, pertaining to a writ of prohibitory interlocutory injunction or a writ of prohibition, there is less restraint on the power of the court to issue that particular order, because as we will see, I think today, or as you would have seen in the notes, if you speak of a writ of prohibition, what we're essentially talking about is that the writ of prohibition would be a common law judicial review remedy. And because it is a common law judicial review remedy, it actually has certain requirements before the court will grant it as a remedy. So the statutory judicial review remedies under the ADJR Act, therefore, are not constrained or circumscribed by the same limitations inherent under the common law judicial review. And we will actually recall that the main reason why there evolved the idea about the equitable judicial review remedies is that when you speak of the common law judicial review remedies such as prohibition, what it essentially means is that the common law judicial review remedies can only be given by the court usually when there are certain elements that would be satisfied. So for example, it will only be satisfied if the one that made the decision is actually one that is exercising a power, is acting judicially, or if you speak of a writ of prohibition, it actually means that you are not dealing yet with a final order. So there is still an opportunity to restrain a tribunal or an executive making a decision from making a final decision. So there are constraints on the exercise of or on the availability of a writ of prohibition as a common law judicial review remedy, which isn't available when you speak of the powers of the courts under the ADJR Act Section 16(1)(d). So, having said that, in this particular case, the answer would be that given that this is a decision made under an enactment, then judicial review remedy, a judicial review under the ADJR Act would be available, and in particular, as correctly pointed out by Clinton, under Section 16(1)(d) of the ADJR Act. The Federal Court of Australia or the Federal Circuit Court has the power to issue an order that would direct the ATO officers from doing or refraining from doing any of the things that are intended to do, including, preventing and prohibiting the ATO from undertaking garnishment. But in that particular case, what would be the reason? What would the right be of Darren Wilkins that would have been violated? Because it's one thing for you to know that judicial review, it's not enough for you to say that a decision was based on an enactment and therefore you can apply for judicial review. The question is there any right, interest, or legitimate expectation on the part of Darren Wilkins that is potentially violated by an order of the court? What is that? Because you need to be able to show that as well when you apply for judicial review. Is there a potential violation of any right of Darren Wilkins? Comment? Comment? Would anyone like to say anything? Is it enough? The question I'm asking really is, if an executive decision is made and the executive decision is based on an enactment, is it then possible for you to argue that necessarily judicial review is available under the ADJR Act? Is that the way it works? Or is there another element that is crucial to jurisdiction being available in a court?
He needs to show that he's been aggrieved or that he's suffered.
That's right. You need to show that he has been aggrieved. You need to show legal standing. And at the same time, you need to show a ground for judicial review. If you don't have standing, if you can't cite a ground for judicial review, why would the court, even undertake judicial review or provide certain remedies? So as correctly pointed out by Clinton, that is very crucial. You need to show legal standing, so you are aggrieved because some of your rights may have been violated. And at the same time, you need to be able to show that you have a ground for judicial review. Clinton, did you want to say something?
If he's got 15 days, how long is the judicial review going to take? Like before it even gets entered? How
long? Very good. Now that's exactly the key point there, because if you file, for example, an action with assuming you don't go through the internal review process of the ATO, because remember, we can always ask for an internal review of the decision. So the ATO itself can stop, its subordinates, a higher officer can stop its subordinates from undertaking any action. But for the moment, leaving aside that idea of an internal review process, if you apply for judicial review under the ADJR Act, if the court is convinced that it is necessary for it to refrain, to restrict or to stop the ATO from enforcing its order to garnish all the bank funds of Darren Wilkins, it can be granted by the court straight away. Did that answer your question?
So is it like, yeah, so like you could walk in there tomorrow and make it happen?
It's really up to the court. The important thing is you apply for judicial review under the ADJR Act, and it will be up to the court to determine if there is legal basis for it to exercise its powers under Section 16(1)(d) of the ADJR Act. So at the moment, we're not dealing with the intricacies of an actual litigation that is beyond, the scope of our course on administrative law. So like, how do you apply, and what are the requirements of actual filing? We don't discuss that in administrative law. Our focus at the moment is, is judicial review available, and if so, what are the judicial review remedies? So, but in answer to your very important question, Clinton, the answer would be that given the fact that one, the decision has been made by the ATO under an enactment, we now know that there is scope for judicial review under the ADJR Act. And we know that if a person's rights have been violated, and we need to identify what those rights are in a short while, but if a person's rights or interests have been violated, then that person would have legal standing. And then the question then is, what judicial review remedy is available? And we know that under Section 16(1)(d) of the ADGR Act, it is possible for a person to apply for judicial review and to ask the court to order the ATO, for example, to refrain from garnishing his or her bank funds. And I go to that question now. What do you suppose is the ground for judicial review? What is the ground? From Karina, Darren will need time to prepare though. That is true. But it won't really be Darren, it will have to be his lawyers. But put it this way, do not be, for the moment, because you're looking at the specifics of it. For the moment, what we need to realize is that lawyers are actually capable of filing applications for judicial review quite quickly. So we have specific examples, which I cited in the lecture notes, where let's assume that the government is about to demolish your house because it feels like your house is a potential danger, and without giving you enough an opportunity to respond to the finding of the government agency, it has now told you that by tomorrow it will demolish your house. What will you do? Of course, you run to the court and ask the court to restrain the government agency from demolishing your house. And it will be very quick for the courts to actually restrain that government agency. I'll give you another example because we're kind of dealing here with some intricacies and specifics. So let's assume that you happen to be an immigration lawyer, and let's assume that there is a finding let's assume that the immigration officer decided that your client, who is here on a temporary visa, has breached his visa conditions. So that person doesn't really have a permanent right to stay in Australia. And so therefore, the visa officer decided that this person has to be deported within the next 48 hours. Now, if you say, but it takes a while for a lawyer to prepare, proper pleadings and so on. So it's, there's no time. Actually, there is time. Lawyers can very quickly, file the necessary pleading and file the necessary application for judicial review. 15 days for 59 sounds unreasonable. That's right. So are we clear about that? Do not assume that lawyers don't act quickly. Actually, they can be very quick. I'll give you another example. Let's assume that I'll give you an example about courts, and it's not about administrative law in particular, but how quickly lawyers can act. Let's assume that you've got a marital dispute with your spouse, and you know that your spouse is of a different nationality or has a nationality with another country. So that person, that spouse of yours might be an American citizen, and because of your dispute, that spouse now wants to bring your 7-year-old daughter to the United States. The question is, how do you stop? And you know that from what you know, your spouse has bought tickets to America, and if that spouse moves over to America, you'll have difficulty, locating where your child might be. So you want to stop that wife of yours straight away from leaving. Well, of course, the easiest way would be to go to the Australian Federal Police. But typically what the Australian Federal Police will then require is that there is an action filed in the Federal Circuit Court at least, or the Federal Circuit Court or the Federal Court of Australia pertaining to a parenting order. So you will have to go to court. Lawyers can quickly do that. You'd be surprised. It all depends on the lawyer though. Okay, so anyway, to make it quick, what is the ground for judicial review? There would be two grounds for judicial review. One is that there could be a breach of the rules of natural justice. Imagine, the funds of Darren Wilkins will be garnished without even giving him an opportunity to explain that, he did not have any liability or that the funds shouldn't be garnished. So that is obviously a breach of the right to natural justice. Secondly, based on the facts, we don't really know if Darren Wilkins is operating a company. In other words, if you're operating a company, that company has a legal personality that is separate and distinct from the owner. So if the car rental business is actually a company, which in law means it has a separate legal personality, then there is no reason why the personal bank funds of Darren Wilkins should be garnished as well, even assuming that there is a liability on the part of that company. So those are two grounds. So that decision would obviously be contrary to law. Okay, so my advice would be that given the fact that the ATO in this particular case, would be issuing an order on the basis of an enactment, then we know that judicial review is available under the ADGR Act, and therefore we also know that Darren's legal standing, because his right to his funds would be violated. We know the grounds because right to natural justice is breached, and even his personal bank funds are affected when it might be that it is a company that he is operating. And finally, we seek recourse. So he has legal standing. So therefore, we seek recourse under Section 16(1)(d) of the ADGR Act, 1977 Commonwealth. Okay. So moving on to question 2. Can I get somebody to read question, or does anyone have a question in relation to question 1 before we move to question 2? We're good? Okay. Question 2. Can I get somebody to read question 2 for us?
I'll read it for you.
Thank you.
The Francois Mills Pty Ltd applied for a broadcasting license with Australian Broadcasting Agency, ABA, and to be allowed to post a bond of $500,000 for the license. Under Section 43A of the Australian Broadcasting Standard Act, Commonwealth, a broadcasting license shall only be issued by the ABA upon payment of a bond of $5 million by an applicant for a license. Section 43 subsection B of the Act also provides that the ABA board has the power, which it may or may not exercise, to reduce the amount of the bond required under Section 43 subsection A of this Act. The ABA refused to issue a license to Francois Mills Pty Ltd until it posted a bond of $5 million. Francois Mills Pty Ltd has approached you as a solicitor for advice. Advise the company on the judicial remedy or remedies that might be available over the ABA decision.
Okay. Thank you, Karina. What do you think? Would anyone care to attempt an answer of question 2?
It's their prerogative, isn't it? That they don't have to. It's up to them if they want to or not.
Very
give
good.
you a 500.
Very good. Go on, Clinton. And as a result,
So they've got nothing to argue about, really.
that's right. There is no error of law. You cannot have judicial review because there is no error of law. Assuming that you can say that it's based on an enactment, and you can argue that potentially can go to the ADGR Act. But that's not the point. What exactly is the error of law involved? There's nothing. As clearly pointed out by Clinton, the ABA is simply exercising a discretion here. And so it is within the power of the ABA within the power and the exercise of its discretion to refuse to issue a license. And in that sense, therefore, what would your advice be, Clinton? What would your advice be?
Go find another $4.5 million.
Yeah, which isn't easy. Yeah.
Go to the bank.
Yeah, so unfortunately for that company, they don't have any judicial remedy. There is no judicial remedy because there is no error of law. And as pointed out by Karina, there is no legitimate expectation that I think that's what Karina is saying anyway, that there is no legitimate expectation on the part of the company that the amount of bond should be less than $5 billion. It can't have that legitimate expectation because it is certainly within the power of the board to require $5 million as the bond. Okay, very good. So final question 3. Can I get a volunteer to read question 3 for us? Volunteer?
Yeah. The Security Workers Commonwealth requires anyone seeking to practice as a security worker in a Commonwealth department, agency or office to obtain a licence from the Australian Department of Social Services and to meet certain requirements relating to education and training qualifications and physical and moral fitness. Sherlock Gordon applied for a security workers licence with the ADSS in compliance with the Security Workers Act. His application was denied, however, because he appeared fat, although his body mass index showed that he was of normal weight. Sherlock has come to you for legal advice about the DSS decision.
Okay, what advice would you give? What do you think? Is there scope for judicial review? NV has been breached. What is NV again? What is NV, Karina? Can't remember. Oh, okay, NJ. So natural justice. Okay. Why do you suppose, Karina, the right to natural justice has been breached in this case? Can I just hear your viewpoint?
I think the question actually says his body mass index, BMI, showed that he was within normal weight. I don't know whether this is the requirement of the under the guideline of the Act, but if his body BMI is within the normal range, he shouldn't be. It cannot be a reason. And what it says in question is that he appeared fat. The appeared fat is just the appearance of the person. The making judgment or decision based on the person's appearance is not. It's
very good. No, the question I'd like to ask really is, why do you suppose, assuming what you said is correct, okay, but why would you suppose that the right that would be breached is the right to natural justice? Why would it be the right to natural justice? Clinton is saying it's probably about bias. What exactly is the right to natural justice? What do we know about that right? I can do it for you. What do you suppose? Yeah, that's right. So the right to natural justice at its core involves the right to be heard when, before somebody's rights, interests, or legitimate expectations are impaired or interfered with by a decision of the executive, a person should be heard. So we're talking here of rights, interests, or legitimate expectations of a person. And before they can be impaired by the executive, he needs to be heard. First question then is, can we speak here of a right, interest, or legitimate expectation on the part of Sherlock Gordon to obtain a license? Does he have a right? Does he have an interest? Does he have a legitimate expectation? Maybe. What do you think? How would you argue that? I'd like to hear your point. Tim, okay, I'd like to listen to that. Very good, Tim. Why do you suppose there is a legitimate expectation? Fantastic. I'd like to hear that.
He meets the requirements for a license.
Yeah. Very good.
Anybody else that put in would likely get it, but he just looks fat. So
yeah. So that's good. I like that. Actually, it did not occur to me. I was actually thinking of another ground. But you're right. Tim is correct that it does, breach the right to certain legitimate expectations. If a person feels that he or she meets certain requirements, then you would have a legitimate expectation that once you meet the requirements, you will be granted the license. So it would be a breach of the right to natural justice then, if your application for a license was simply rejected because and without giving you an opportunity to be heard. That's correct. So I agree fully. I agree fully that there is a breach of natural justice here, as correctly pointed out by Karina and by Tim. What is another ground here for judicial review? So we have one ground would be a violation of the right to natural justice. Is there another ground that you could cite? Karina, reasonableness. Can you tell me what that is about, Karina?
a reasonable person would not have made that decision.
Very
Based
good.
Yeah, to refuse the application based on the appearance.
Very good. That's correct. I agree with that as well. So if you look at Section 5J of the ADGR Act, when the exercise of power involves the exercise that is so unreasonable that no reasonable person could have exercised that power, then that is a ground for judicial review, which is actually similar to Winsbury and reasonableness. So there are two grounds. One is the ground of unreasonableness under Section 5J of the ADGR Act, and we have the breach of natural justice, again as a ground under Section 5 of the ADGR Act. Very good. Okay. So, and in that particular case, what exactly would be the particular judicial review remedies that you would ask from the court? So we know that you've got legal standing. You know that ADGR Act is available because the decision is based on an enactment. We know the grounds for judicial review. What exactly are the particular judicial review remedies that you will seek from the court? Mandamus. Aha. Let's look at that mandamus, although it's past 7 now. Mandamus, is that available? I mean, of course, we're not using the word mandamus, okay, because mandamus isn't really in the ADGR Act. But more or less, the idea that the court can be the ADSS can be compelled to act in a particular way. Would that have been available? So let's just use mandamus for now as a shorthand for what we think. Is that correct? What exactly is mandamus? So mandamus would have been a common law judicial remedy, wherein a court would order an executive to fulfill a public duty that has not yet been performed. So, and it also involves on the part of the person, or on the part of an applicant, that person has a right. In this particular case, I would think that mandamus as a shorthand, I wouldn't think that would have been available because there is still on the part of the ADSS a discretion. It will have to be the ADSS that will determine whether or not that person is actually qualified, and it's not easy to see that that Sherlock Gordon automatically has a right to the license. There is still something that needs to be determined by the ADSS. So I would strongly doubt that mandamus would have been a particular remedy. But as pointed out by Clinton, you will see that under Section 16(1) of the ADGR Act, it is possible, of course, for you to seek a prayer for the federal court or the Federal Circuit Court to declare that he does have a right to a license. That could be under Section 16(1)(c) of the ADGR Act, or to direct the ADSS to grant him a license, which is almost similar to mandamus, but mandamus has to be distinguished because if you speak of mandamus, you're now talking of a public duty. There can be no public duty on the part of the ADSS to just issue licenses. That really involves a discretion. So it will be difficult to argue. So Karina was asking about prohibition. Again, we're using prohibition here as a shorthand, right? To kind of refrain an individual, an officer acting judicially from doing something, okay? We're using that as a shorthand. But what instead we should be doing, because we're looking at the ADGR Act, is simply to look at Section 16. And we know that in Section 16, the Federal Circuit Court or the Federal Court of Australia has the power to quash a decision or set aside a decision. Okay. The problem, however, really is that if that is what you're asking the court to do, you want the court to set aside its decision not to grant him a license. What is the end result? So if that were the prayer, you're asking the court to order, to quash the decision of the ADSS not to grant Sherlock Gordon a license. Would it mean that Sherlock Gordon ends up with a license? He still doesn't have a license, right? Is that correct? Okay. So, but you're right. Correct. So, yeah, Karina is correct. I agree with that. That if there is a decision on the part of the court to quash the original decision, it will likely be the case that the ADSS will now have to assess his application according to the law, and especially because the court will normally provide directions on how the ADSS should be acting in this regard. Again, what we need to remember is that as far as judicial review is concerned, even under the ADJR Act, a court usually will not substitute its own decision for that of the original decision maker, nor will a court change or revise a decision or vary a decision of the original decision maker generally. I use the word generally because there have in fact been instances when courts have in fact directed the executive to take particular action, even if they were simply exercising the power of judicial review. So I would agree with Karina that one, it will in fact be helpful to apply for judicial review, a particular judicial review remedy to quash the decision, because if the court quashes or sets aside that particular decision which did not grant a license, it actually would mean that the ADSS will have to review its decision and wonder if the proper way of approaching it according to the law would in fact be to grant the license. Okay, very good. Questions before we end tonight's session? So hopefully, you've got a better sense now about judicial review, and we've gone to the intricacies of judicial review remedies. Okay, so I think we're good. Yep. Thank you very much again, Harry, Karina, Rebecca, and Clinton for joining tonight's session. And I'll see you next week. Good night. Bye. Thank you, Karina. Thank you, Tim. Thank you, Harry. Good night.